My lord, kindly, my lord, to mention, my lord, that this section 34, my lord, the electro-steel casting load against railways. Your lordship was hearing, my lord, your lordship has heard it on 10th December, 7th January, my lord, and 14th January. My lord, if not, your lordship, my lord, could fix a date, my lord, for hearing, because otherwise, my lord, will, my lord, it's in the monthly list, my lord. If it could appear in the daily list, my lord, any day convenient, your lordship.
We'll see. We'll see, Mr.
My lord, may I give the cost title to your lordship?
Just give the cost title,
I'm
we'll see.
good.
Have your lordship's leave to mention, lordship, there's a perjury application appearing in the monthly list as item number 227 has been, affidavits have been exchanged back in October, my lord, October 2025. If it can be put in the daily list and heard anytime, my lord.
What is the urgency?
Lordship, there's a perjury application and the parallel arbitration proceeding is almost on the verge of ending, lordship, if it can be heard.
No urgency, sir.
Okay, humbly pray for my lord's kind leave, my lord, to furnish the bank guarantee filed. My lord, the department has given me a letter. When the bank guarantee is ready, my lord, I'm just submitting to my lord.
Move an application, sir. Move an application. Bank guarantee cannot be given over the.
My lord, I'm humbly praying for my lord's leave so that I can file it in the department, my lord. Because the department, my lord,
It has expired. The time has expired.
My lord,
Right? Then you have to move an application.
my lord.
Then only I can pass an order.
My
Or without anything, I should pass an order.
my lord.
What kind of mentioning is this?
Lord, may I permit to mention in my 5 matter, I have instruction to withdraw this execution of leave.
Your Lordship, item 96 of the monthly list, under section 36(2), there was a direction to deposit the amount with the Registrar General. I have moved an application. The same could not be done within the time due to some miscommunication. If it could be taken up because the execution proceedings are being executed, so I was seeking if
Application has already been filed.
Your Lordship, it's appearing in the monthly list as item 96. Obliged.
Lordship, may I have your leave to mention 2 execution matters? Lordship, there is a settlement which has been entered between the parties and the payment is being made in parts. The warrant of arrest is there against the award debtors, Lordship, for making the warrant of arrest stayed for some time for that. Lordship, they are paying.
You are using warrant of arrest as a means and mechanism of getting the matter settled.
Lordship, they have entered into a settlement and they are paying in installments. That is, and they will be finishing the installment by.
Withdraw the matter, madam. You're not going to use this court as a method of harassing people, getting warrant of arrest issued, and then, entering into a settlement and making sure the court goes by your dictates. I'm sorry. I will stop issuing warrant of arrest against any of your clients now. Either you withdraw it or don't ask for this prayer. Don't do this. We are not sitting here to recover your money.
Lordship, in this matter, the matter has been settled between the parties. I wish to withdraw.
Take down. Learned counsel for the petitioner seeks to withdraw the present petition since the matter stands settled between the parties. Dismissed as withdrawn.
Lordship, there is a warrant of arrest, interim order.
Any interim order stands discharged.
Your Lordship, I am award debtor in item number 2.
Your Lordship, and for the award holder, there's been settlement between the parties.
The award debtor has filed section 34, which is item number 5 in today's list. Both matters has been settled between the parties.
Your Lordship, that is not my application. I am not appearing on the section 34.
So you withdraw the 34. This is
Let both the matters be withdrawn.
34 is item
5. No.
monthly list.
Today's list.
Kashish textile.
Yes.
And this is item number
2. Item number 2. There's been settlement between the parties and kindly withdraw the matter.
Take down.
The matters.
ECCOM.
There was an interim order, Your Lordship.
Learned counsel for the petitioner states that the matter stands settled between the parties. She wishes to withdraw the present petition. The same is dismissed as withdrawn. Full stop. Item 5. Learned counsel for the petitioner states that since the matter has been settled between the parties, she does not wish to press the present petition. The same stands dismissed as withdrawn.
Your Lordship, there has been also settlement between the parties. Kindly withdraw the matter. And there was an interim order. Your Lordship, there has been a settlement between the parties. Kindly withdraw the matter.
Yeah.
There is an interim order.
Any interim order stands vacated.
Lordship, this matter has been settled between the parties. I wish to withdraw the matter. Lordship, the receiver can be discharged.
You're the receiver?
Yes, ma'am.
Asset has been returned.
Lordship, here we have not taken the receiver. Before that, the matter has been settled.
Learned counsel petitioner seeks to withdraw the present petition since the matter stands settled between the parties. The receiver is discharged. The present petition is dismissed.
Grateful.
You have received your money.
My lord, ma'am.
Please pay the money to them.
Lordship will do that.
Pay the money. Madam,
do that.
don't do that. You should have paid the money to the receiver.
Lordship.
Yes, ma'am.
If you don't get it, file an application. I'll get you 5 times more.
Mine.
Lordship, I appear on behalf of the petitioner, Your Lordship. Yesterday I had sought time for completion of service, Your Lordship. Service has been completed, Your Lordship. May I file the affidavit of service, Your Lordship?
They have been served?
Yes, Your Lordship, it has been delivered yesterday.
Affidavit of service taken on record. Despite service, none appears for the respondent. There's only one respondent, huh?
Yes, Your Lordship, only one respondent.
Yes, now tell me.
Respondent.
Tell me, what is it?
Yes, ma'am. The arbitral proceedings, my lord, as of today, my lord, at the stage of argument has been completed.
Verge of completion.
On the verge of completion, and probably in a 3 or 4 months, my lord, the order will be passed. There has been two extensions in the past, my lord, but my lord, at this stage, my lord, would really pray for my lord extension. Although the first sitting, my lord, yes.
The arbitration started in 2020.
Yes,
I was. It is only because the advanced stage, my lord, I would pray for an extension. On the last occasion, there was some dispute, but my lord, another complete.
payment has been also.
How do I say this? But the arbitrator's remuneration has already been paid by both the parties. If at this stage, if I pray for any substitution, it will really prejudice both the parties. Order closer. Extend.
First order.
Why so much delay?
From time to time, the arbitrator has been a little under the weather, and other than that, because of COVID period, there has been some delay, and subsequently during somewhere in 2021-22, some additional documents were disclosed. On that, application hearing was made. I absolutely, the timeline doesn't look very inspiring. 2020, and we are in 2026. But my lord, the other side, my lord, has also, my lord,
Indicated.
not officially, I cannot, my lord, place any record, but indicated that they will not, because they are also on the same boat. They have also, my lord,
Paid the remuneration.
paid the remuneration and everything. First extension.
First extension 9 July 2025, page 36.
Page 36 is the first extension, Lordship. Okay.
Second, page 51.
This is a unilateral appointment.
Yes, Your Lordship.
Will they survive?
Unilateral
Have they
appointment.
agreed to it?
Chairman and Managing Director of the respondent appointed Tanmoy Roy. Will it survive?
হ্যাঁ, এবার করেছিল। Both
But my
parties have
instruction
agreed.
is that both parties have agreed.
They are participating in
They are
arbitration.
participating and they have the wait for it. I was
Okay.
not there in the arbitration. I'm not there.
See, today they can file a 34. This will get
Correct,
set
correct,
aside in
correct.
1 second.
So you have appointed. They have agreed to the appointment. 12/5 wait for it.
It is there. We had asked for. হ্যাঁ, আমরা তো
You seek instruction.
In fact, they had appointed.
Yes, they had
We are the
appointed.
claimant.
We had agreed.
They had
They had
appointed.
agreed.
Yes.
Yes.
The chairman and managing director of the respondent appointed.
Yes. Respondent had appointed.
It's 16, 17 arrears.
Page 16 and 17, Lordship will find the communications. Hello.
Arbitration আবার হচ্ছে না। আমার
36 is the first extension.
Take down. The petitioner has preferred the present application under section 29A of the petitioner has preferred the present application under section present petition under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of the mandate of the arbitral tribunal for conclusion of the arbitral proceedings and publication of the award. Full stop. Learned counsel for the petitioner submits that the chairman and managing director of the respondent white letter dated 3/2/2020 appointed Mr. Tanmoy Roy as the sole arbitrator to adjudicate the dispute between the parties. Full stop. The petitioner agreed for the said appointment and the arbitration to the said appointment. Full stop. The first sitting was held on 2/9/2020 and the pleadings were completed within 6 months from the first sitting. Full stop. Due to COVID pandemic, there was delay in the proceedings. Full stop. This court-wide order dated 9/7/2024 and 1/5/2025 extended the mandate of the arbitral tribunal by 6 months and 8 months respectively. Full stop. Learned counsel for the petitioner submits that now the mandate of the tribunal has expired on 1/1/2026. He further states that the matter is at the stage of final argument. Full stop. The tribunal has already conducted more than 28 sittings. Full stop. Notwithstanding the considerable delay in conclusion of the arbitral proceedings, upon perusal of the materials placed on record, this court is satisfied that the matter has reached an advanced stage of the matter is at an advanced stage of proceeding. Accordingly, in the interest of justice and to enable culmination of the proceeding, the mandate of the learned sole arbitrator is extended further for a period of how much time? 3 months?
We have for 100%, we have paid for 6 months, and I'll leave it to a lordship.
So will it be concluded for a period of 4 months from date? Full stop. The sole arbitrator is requested to make all efforts to conclude the proceedings and publish the award within the extended time period. Full stop. With the aforesaid direction, the present petition stands disposed. First line in record.
Lordship,
I appear for the petitioner.
Lordship, I am for the respondent, my plain for past server.
Passover. Why?
My senior was another.
Well, it's a section 29A, my lord, and it has been served on them.
Any objection to the application?
My senior was another on the way.
What is your instruction, madam? Any objection to the application?
No.
Then I can pass an order.
Yes, plenty for short Passover.
Not
Give the
today,
pass.
tomorrow.
Calcutta. Look, it's 2 matters. Same, my lord. 8, 9, 10, right?
10 or 11?
8, 9, 10.
11.
11. 8, 9, 10, 11.
Pass it over. We'll take it. We'll finish it off.
Pass on.
Pass over. All four pass.
This is my application, Malad, under section 12 and 29. 29A. Sorry, Malad. I was just doing a matter, Malad. I'm so sorry. It's under 29A. But Malad, I must just point out, Malad, because Malad, once we have taken out this application, it appears that the other side has now taken out an application, Malad, very unheard of, under section 14, read with.
I am for the other.
Under section 14, read with 29(6), saying that the arbitrator is biased and therefore substitute. But Malad, there's been no application at 12 and 13 before the arbitrator. So that has not come up. But my application is 29A, Malad, 22nd. It was supposed to, Malad.
Only one thing, my lord, we have filed this application, my lord. My lord, outstation counsel is appearing in this matter. My lord, kindly fix both the matters, my lord, together, my lord, on 9th, my lord, 9th March, my lord. We want to file an affidavit in opposition to this application, my lord. Kindly, my lord, because the outstation counsel is appearing.
Malad, retired judge, Malad, they are nominee. We had accepted. Now, Malad,
My lord,
this is
kindly
biased.
because my lord, in our application we have given certain instances on which, my lord, there's certain
And that application is
circumstances.
not appearing today, I must be.
No, my lord, it
Kindly.
is not appearing.
Yeah.
My lord, it has been affirmed, my lord, yesterday only. My lord, it will be filed. My lord, kindly keep both the matters, my lord, nice, my lord, kindly, my lord. No, it has been affirmed.
No, that has not been filed. As
My lord, it
has not yet been filed. It will be filed.
Hussain, you're appearing?
Yes, he is appearing.
Yes.
Unfortunately, my lord, we are filing an application also, my lord. So, my lord, I think it should be heard together, my lord. So this is not an usual
If I
29.
file my 29A, Malad, I'm sure it will be the domain of the arbitrator to continue if he wants to. But that's a different thing altogether.
That's a different thing.
I'll leave it upon your lordship. They have not yet filed, Malad.
No,
So
it
has been affirmed, my lord.
But may I COVID rakte bolungi? 9th March, my lord, if it may come, both these matters together, my lord.
You have not even filed it.
It has been affirmed.
It has been affirmed, my lord.
Today, we
Today
have
I can-
already served the other side.
There's already
action.
yes, my lord. Then this my application.
It's only been affirmed. There's no number which has been allotted.
May I come back and give your lordship's officer the number? It can appear day after tomorrow, my lord. Then we can have a direction for affidavit in both the matters together.
What is the difficulty in the extension?
There are some difficulty, my lord. I'll tell you, lordship, my lord. First of all, my lord, the time, if the time is to be extended, it has to be shown that without any, there has been a proper justification for the time to lapse. My lord, I'll tell you, your lordship will see, I'll give your lordship a chart. How much time we have taken to file pleadings. And apropos, for the same pleading, like I filed statement of claim, how many extensions have been granted as a matter of course to file the statement of defense? Similarly, for affidavit in chief of the witness, total 3 months have been taken to allow the affidavit in chief to be filed, despite, my lord, a direction, my lord, that it has to be peremptorily filed. It is not just one extension. as a matter of course. But I should give your lordship a chart. I have
Whatever
written
he's
a
saying,
chart
but
of
does not
list of
fall
names.
under any of the schedules, my lord.
Of
So,
course
my lord,
it
it's,
does.
no, it
Of
doesn't.
course it does.
It
Then
doesn't.
I'll tell you.
Under Schedule 5 or Schedule
If
7,
I
doesn't.
allow, if the arbitrator,
Neither
It's
schedule
under
5
Section
nor
19, that's the domain of the arbitrator.
no. So therefore, if the
Procedural.
arbitrator has exercised discretion in such
But
a
he can
manner,
ask for damages at the end. He can ask for that. Costs of
I mean,
arbitration.
there are some
Is that a
There
ground?
are some other grounds, my lord. I shall have to
Is that a
place my case.
ground?
My lord. I shall have to place my case. Kindly see, my lord, it sounds embarrassing.
Your own nominee, how can it be more embarrassing than that?
Definitely. But doesn't mean, my lord, since I have.
But at first things first, my lord, it's not maintainable without a 1230.
Very well. Well,
Then how can he?
14,
So
my lord,
there
let's
is no,
come 14.
my lord, there is no application, my lord, kindly extend this. If
No, my lord,
it is found to
I
be
have a
biased,
right
my lord,
to
your
file
lordship
an
will remove
affidavit.
him.
Very well. Forget about my application. I just have a right to file an affidavit to say that an application under 29A is not a matter of course. Lordship has to see the circumstances in which how the arbitration has proceeded with. Whether the arbitration has been proceeded with due diligence and to what extent the arbitrator has exercised his discretion.
That you can show from the record, Mr. Singh. You don't need to file an affidavit
Very
for
well.
that.
Your lordship will keep the matter, my lord. I shall show it, my lord.
Show from the record.
Yes, I shall.
Show from the orders.
Yes, I shall.
What is there that
I am in a
is
position
causing
to
you
show that.
prejudice?
I am in a position to show that from the minutes only. Kindly keep it, my lord, next week so that I can come, my lord, and show
Not
it.
today, 9th.
Not today, my lord, it may come tomorrow.
Because your application is not there.
No, I'm not saying about my application, my lord. I just, tomorrow I am some in difficulty, my lord.
So not tomorrow. I will keep it on 9th only, not today, 9th.
Very
9th of March.
well.
Keep it for 9th of March.
Well, may I just suggest this, my lord? If he wants to file an affidavit to this, let him file it by that time. Or else, my lord, what will happen on 9th? He will come and ask for an
No,
affidavit.
I'm making my stand clear. Since
Oh, then I'm fine. Then I'm fine, my lord. If he's not going to file an affidavit, I don't have a problem.
lordship feels that it is not necessary, I'm
Again,
not going
feeling
to.
is a different thing. But feeling is a very different thing.
Let him file. Take down. Petitioner has preferred the present application under Section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal for completion of the pleading and publication of the award. Full stop. Learned counsel for the petitioner states that the when was the arbitrator appointed? Learned counsel for the petitioner submits that the respondent violated
15th of
27/4.
nominee. This was
Well,
Section 21 notice.
Section 21 notice provided for that, Mother, to 15 December
27/4.
2023.
Your letter of 27/4, right? You have Mr. So-and-so was appointed by letter dated. This is your letter.
Well, it is 22nd March 2024, page 24, Mother.
This is letter of?
This is the letter issued by my learned friends,
We are the
advocate and
claimant,
advocate,
but I am the
the
claimant.
claimant to the learned arbitrator, my lord. My lord, kindly sees, my lord, the arbitrator is named on that letter, my lord, 24. And my lord, it's written by them that we are being appointed as a sole arbitrator.
The respondent by letter dated 22nd of March appointed Mr. Ashok Kumar Dasadekari, Honorable Justice Ashok Kumar Dasadekari, bracket but retired, as the sole arbitrator to adjudicate the dispute between the parties. Full stop. The petitioner states that the pleadings were completed. When were the pleadings completed?
Well, the pleadings were
completed on 22nd of August, 2025.
22nd of August, 2025.
2025. And
2024.
2024, man. I'm sorry, man. 2025 is just
2024.
Man, it's just
And the
stage of
parties
final
by
hearing.
mutual consent extended the mandate of the arbitral tribunal by 6 months till 22 to 2026.
22nd February.
2025, right? 22 to 2020,
26, man.
2026. Full stop.
It's the stage of final hearing, man.
The matter is at the stage of final argument.
Arguments they have started, man.
Final arguments. And the next date is fixed for 19/3/2026. Full stop. Learned counsel for the respondent states that he has objection to the extension of the mandate of the arbitral tribunal since full stop. He seeks and is granted 2 weeks time to file his affidavit in opposition. Reply, if any, within 1 week thereafter, list after 4 weeks.
But then we'll cross 9th, man. But if they want, let them file 10 days.
Within 1 week. Within 1 week. 1 week.
1 week, and I'll file it before 9th, man.
1 week. And within
before 9th, I'll file. So that the hearing can be, because the next date is 19th, man.
19th.
We can do it before the 19th, man.
So we'll do it before the 19th. And then we won't keep it for I'm going on the circuit, so we have to do it before that.
And your lordship is leaving on the 16th, I believe.
Yes. So we'll keep it on the 11th then.
11th.
All right. 1 week will be.
I can do 1 week, 5 days, man. I don't need so much of time.
Takes 1 week's time to file reply.
3 days. 1 week, 3 days, 9th.
Affidavit in opposition, reply to the same within 3 days thereafter, list on 11th.
Very grateful, man. Because they have someone coming from outside, so that's why I thought that
11th.
I'm very grateful for that. Grateful.
Lordship, my application for extension of the mandate of the learned arbitrator. Lordship, if I may file my affidavit of service. Lordship will kindly take note at page 55 is the minutes of the meeting whereby the learned arbitrator has reserved the reference for only for the purpose of publication of the award, after which we approached your lordship for extension of the mandate on 19th November 25. Your lordship was pleased to extend it for 3 months, lordship. Lordship, that date has expired on the 18th of February. However, lordship, if your lordship looks at the letter at page 58 by the learned arbitrator, the learned arbitrator has paid for some more time, lordship. So it's only for the purpose of publication of the award. Lordship, the learned arbitrator has prayed for a week's time. If I may pray for an extension of 1 month, just as an abundant caution, lordship.
And the petitioner has preferred the present application, present petition under section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal for publication of the award. Full stop. Learned counsel for the petitioner submits that the parties by mutual consent appointed the learned sole arbitrator to adjudicate the dispute between the parties. And by letter dated 7/12/2018, the learned arbitrator communicated his consent to act as the sole arbitrator. Full stop. The pleadings were completed on 22/11/2021. Full stop. Hence, the mandate of the arbitral tribunal expired. The mandate of the arbitral tribunal expired on 22/11/2023, with the consent of the parties, the mandate was extended up to 21/5/2023 for a period of 6 months. Full stop. Thereafter, this court-wide order dated 17/5/2024, 20/11/2024, and 3/11/2025 extended the mandate of the arbitral tribunal for a period of 6 months, 1 year, and 3 months, respectively. Full stop. It is contended by the learned counsel for the petitioner that the mandate of the arbitral tribunal expired on 19/2/2026, full stop. He further states that the arguments have been have concluded and the award is to be published. Upon consideration of the materials placed on record, this court is satisfied that there is no delay attributable to the learned sole arbitrator in conducting the proceedings. Full stop. In order to ensure expeditious conclusion of the arbitral proceedings, this court deems appropriate to extend the mandate of the learned sole arbitrator to publish the award within a period of and thus extends the mandate of the arbitral tribunal further for a period of 1 month from today. Full stop. The learned sole arbitrator is requested to make all endeavors to publish the award within the extended time period. With the aforesaid direction, the present petition stands disposed of. 1 month should be enough. Affidavit service taken.
Lordship, if I may hand over the notice of motion, Lordship.
Notice of motion?
Lordship, the notice of motion along with the.
Huh? Affidavit is there.
Grateful.
I appear for the respondent, my lord. I was addressing your lordship, my lord, yesterday.
Mr. Banerjee. Yes, if you can just recapitulate your argument in 2 minutes.
Yes. So this is a section 29A application for extension of time, my lord, for the arbitral proceedings to continue. Now, my lord, in this, my lord, the section 11 application was filed before this court, and my lord, after the appointment of the arbitrator, this I must point out also, I just got to know yesterday, my lord, that they filed a review before this honorable court against that order. That review was dismissed, my lord, on the ground that the review is not maintainable. Now, my lord, in that review, they had in fact raised the point of jurisdiction also, because this is very important with the facts of the case. My lord, may I just hand over the copy of the order passed by Justice Kapoor? Shamne paste it. Kindly see paragraph 4. The only issue raised by the applicant is on the ground of territorial jurisdiction, which again they are raising now. The grievance of the agreement being insufficiently stamped. This my learned junior friend has given up, my lord, so I'm not getting into it. My lord, kindly sees the next line. It is submitted that the order dated 22nd December 2022 suffers from an error apparent from the face of the record. This is very important, my lord. I think, my lord, lordship, my lord, they're trying to make my lord an appellate court, as no part of the cause of action arisen within the jurisdiction of this court. Neither of the parties reside within the jurisdiction of this court. The mere fact that the place of arbitration has been recorded in the arbitration clause as Kolkata does not confer jurisdiction on this court to exercise powers under section 11 of the Act. In this regard, the applicant relies upon the decisions of my lord Hakam Singh and all he has relied upon. On behalf of the respondent, it is contended that the review application is not maintainable and there is no mistake or error apparent on the face of the record. The order was passed after giving repeated opportunities to the petitioner. In the garb of review, the petitioner cannot enter into the merits of the order and seek full-fledged hearing. There are no grounds which warrant review of the order. Then, my lord, the provision of the CPC is, my lord, set out. The grounds enumerated above are specific and well-defined. The power to review is a creature of statute. This must be conferred by law, either specifically or by necessary implication. And apropos this, my lord, kindly comes to the next paragraph. Paragraph 9. The only ground which is raised is one of territorial jurisdiction. Clause 13 of the master facility agreement is as follows. The same clause which my learned friend is opposing now before my lord was considered. The term mistake or error or apparent by its own connotation signifies an error which is evident per se from the records and does not require an examination, scrutiny, and elucidation either of fact or of law. If an error is not self-evident, it cannot be termed as an error apparent on the face of the record. A decision which is erroneous in law is certainly not a ground for review. In exercise of the jurisdiction of Order 47, Rule 1 of the Code of Civil Procedure, it is not permissible for an erroneous decision to be reheard and corrected. Then the judgment is given. There are no grounds whatsoever and the review is, my lord, dismissed. Now, my lord, if I go by this order or judgment, then, my lord, he was aggrieved. My learned junior friend was aggrieved by the order of Section 11, saying that the Section 11 court, which had passed the order appointing the arbitrator, did not have jurisdiction. So, my lord, the way open for him was to prefer before the Supreme Court. Now, my lord, he did not. So, my lord, therefore, he accepted that, my lord, this honorable court is the superintendent court. So, if this honorable court, my lord, is the superintendent court and he has taken this particular issue, my lord, which, my lord, he is harping now, is then, my lord, that, my lord, is rested forever. My lord, he cannot re-agitate that once he has failed in the review. My lord, he had an option. He did not exercise it. Now, my lord, the arbitration started. It is, my lord, at the stage of, I think, argument. Evidence. Interlocutory. Let us take, my lord, interlocutory straight. My lord, he has not preferred any Section 16 also there. Now, my lord, he had taken the point of stamp duty. That was impounded. He said, my lord, he admitted he is not going to take that point again. Now, here before my lord, when the Section 29A is, my lord, being considered, he comes up again with the same issue in a different way, clothed, my lord, saying that this court is not the 2-1E court. It is the same thing. Section 11 saying not having Delhi, then Delhi High Court should have had. He could have argued it before the Supreme Court. He did not. Now he is saying 2-1E because that is the way to enter before my lord. He cannot say, my lord, with regard to Section 11 before my lord. So, my lord, he is saying 2-1E. Now, my lord, in 2-1E, my lord, lordship sees, my lord, lordship has to look into, my lord, whether lordship is the 2-1E court or not. Now, my lord, as my lord recorded in the review order also, my lord, the clause sets out that the seat of arbitration, my lord, is at Kolkata. And, my lord, part cause of action is all that one needs to show is that, my lord, when a supplementary affidavit was filed in this proceeding, my lord, it is recorded that, my lord, the agreement was signed at Delhi, correct? And it was sent to Kolkata, wherein, my lord, within the jurisdiction of this honorable court, the offices of the petitioner lies, wherein, my lord, it was executed and concluded. So, therefore, part cause of action also arises before my lord. Then, my lord, the seat is undoubtedly before this court. Now, he says, my lord, that part cause of action has not arisen. Now, my lord, this part cause of action has arisen, my lord, this is rested because, my lord, otherwise he should have preferred an appeal from the Section 11. He cannot re-agitate that. Now, my lord, seat. If your lordship sees seat, my lord, Kolkata is, this honorable court is decided by, my lord, Justice Bhattacharya's judgment. Justice Bhattacharya has given a different view. I'll my lord, distinguish the judgment once he shows it in a different context with regard to a different, my lord, clause in that agreement. That clause was different. I'll show it, my lord. Now, apart from that, my lord, I showed Balco also, which says, my lord, the choice is with the litigant. Even, my lord, BGS Soma does not set aside Balco. It cannot because it is, my lord, a bench which is larger than BGS Soma. It only discusses it and stops there. Now, it says, my lord, either it has to be before the court, which, my lord, where part cause of action arises, or seat. And, my lord, if your lordship takes Indus Mobile, it, my lord, rest, everything says seat is what you're going to look into. Now, my lord, his contention is that, my lord, this court is not the, my lord, ordinary original, my lord, court, principal court, because there are two courts. Now, my lord, kindly sees, my lord, that also I showed from the judgment of Justice Nariman in that West Bengal, my lord, associated contractors, where, my lord, similar, my lord, issues were raised. where my lord City Civil Court at Mumbai was there and the Mumbai High Court was there. My lord, the provision 2(1)(e) says, my lord, the court which is superior, not inferior, in the district. Undoubtedly, my lord, lordship is the commercial court which is superior in the district. Secondly, my lord, it cannot go to City Civil Court because of the amendment made to the West Bengal laws, my lord, in the commercial division, where it says, my lord, anything above 1 crore, lordship has got exclusive jurisdiction, pecuniary wise. The claim here is undoubtedly more, my lord, because it is 2 crore and something. So therefore, my lord, under all circumstances, my lord, 29A will not, my lord, lordship will not get into it because prima facie, my lord, this is the 2(1)(e) court. But now I say it is not even prima facie because, my lord, he is not preferred an appeal from the section 11. I would have understood he would have gone before the, my lord, Supreme Court saying that Delhi High Court has got jurisdiction and therefore it was wrong on the part of, my lord, Calcutta High Court to appoint an arbitrator. That was there. But it chose not to. So I think this order, once I got it last night, I think, my lord, it is futile now, my lord. It has become academic, absolutely. And, my lord, I showed also BGS Shoma to show that, my lord, venue and seat are now the same. Otherwise, it's curial law which applies because of which, my lord, it is. So, my lord, my lord, pray that, my lord, it may be extended and the arbitrator can continue with the proceedings. That is all, my lord. That is what, my lord, if I may recollect, my lord.
First, I'll deal, my lord, with the judgment that is there, that was shown. Lordship would take the order that has been passed in the in this application itself on the 13th of August 2024 by Justice Bhattacharya. Lordship would turn to the second page. It is argued that, my lord, has it? It is argued that although on a prior occasion the arbitrator was appointed under Section 11 of the 1996 Act, where such objection was not taken, and subsequently a review application of the said order had failed, despite the respondent having raised the issue of jurisdiction, the said orders do not operate as res judicata insofar as the present matter is concerned. This is for the simple reason that the contemplation of Section 11 is before the Chief Justice of the High Court having territorial jurisdiction, which is completely different and distinct from the principal court having original civil jurisdiction. As for example, it is argued that there are several principal original civil jurisdiction courts spread over different parts of Kolkata depending on the territoriality of the subject matter. So, my lord, in my most respectful submission, the Section 11 and the review thereto has no relation with the scope and purport of the present application, because your lordship would recount, my lord, under the Arbitration and Conciliation Act, for the entire state of West Bengal, there is only one appointing court under Section 11, that is, my lord, the Honorable Chief Justice or his designate Honorable Judge, for the entire state of West Bengal. But that does not mean, my lord, ipso facto, that for the entire state of West Bengal, this Honorable High Court becomes the 2(1)(e) court. They still have to satisfy the requirements of Section 2(1)(e), and that is, my lord, where I join issue in this case. My most respectful submission before your lordship today is this. The Honorable High Court at Calcutta is not the 2(1)(e) court for the purposes of the present Section 29A application. My lord, that is my most respectful submission. And my lord, the Section 11 and the review thereto has no relation with the considerations under Section 2(1)(e) because Section 11 does not even use the word court. It uses the word High Court. So they had nowhere else to go. Yes. And even on the first day also, my lord, the arbitration clause spelled out the word Kolkata. But despite that, his lordship felt at that point of time that this is an important consideration which needs to be looked into. Your lordship would kindly take the same order. On the third page. Learned counsel appearing for the petitioner, my lord, has it at the top. Appearing for the petitioner controverts such submissions and argues that even if there was no occasion for pleading the facts regarding jurisdiction of the principal civil court of original civil jurisdiction before the arbitrator, in view of the jurisdiction clause / forum selection clause in the arbitration clause itself, if necessary, the petitioner is agreeable with leave of the court to file a supplementary affidavit to furnish sufficient particulars or pleadings in that regard. So, my lord, the only reason that the supplementary affidavit was filed was because necessary pleadings and facts were not brought on record, which showed that this honorable court was the 2-1E court. And my lord, I showed your lordship the supplementary affidavit yesterday, where they have pleaded that negotiations took place in Calcutta. So a part of cause of action has arisen within the original side. Because, my lord, they take an address of Lord Sinha Road. Now, my lord, my answer to that, my lord.
Interrupt once, my lord, my learned friend. I did not say negotiations. I said negotiations and conclusion of the agreement.
Yes.
So you
Correct,
should
my lord.
address that also.
Yes, yes. Now, my lord, I have shown your lordship the agreement yesterday. My lord, I will show it to your lordship once again. Your lordship would recollect the entire stamp duty of the agreement is paid in New Delhi. The agreement is admittedly executed in New Delhi. Today, if my learned senior says that an agreement is executed in New Delhi, performed in New Delhi, money is sent from Bombay, but it is concluded within Kolkata, your lordship will not look into it, and your lordship cannot look into it because of the Indian Evidence Act. If there is a document on record, that document will speak for itself. Your lordship would take section 92 of the Indian Evidence Act.
Yes.
In fact, Ballot will take from section 91. It even sees the heading of the exclusion of oral by documentary evidence. When the terms of a contract or of a grant or of any other disposition of property have been reduced to the form of a document. Admittedly, my lord, there is an agreement executed in New Delhi. And in all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in proof of the terms of such contract, grant, or other disposition of property or of such matters except the document itself. Or secondary evidence, but no one is running the case of secondary evidence here. And then your lordship takes 92. When the terms of any such contract, grant, or other disposition of property or any matter required by law to be reduced to the form of a document have been proved according to the last section. It is his document. He has proved it before the arbitrator. Even before your lordship, he says this is the agreement. Have been proved according to the last section, no evidence of any oral agreement or statement shall be admitted as between the parties to any such instrument or their representatives in interest for the purposes of contradicting, varying, adding to, or subtracting from its terms. Well, my most respectful submission is by way of a supplementary affidavit and by merely stating that negotiations took place in Calcutta and contract was concluded. That cannot be admissible in terms of the specific bar on oral evidence when a document is there on record. Your lordship would merely look at the document and its purport. Now, my lord, even assuming his best case, my lord, that negotiations took place in Kolkata within the original site at Lord Sinha Road, as my learned senior says, my most respectful submission apropos that is, even that does not, my lord, create a cause of action. Because, my lord, what is a cause of action for...
But what about the clause itself?
Yes,
Lord, the agreement.
My lord, may I just complete this point and I'll come back to the clause, my lord. That will be convenient, my lord, for my argument. So, my lord, this is the only judgment I'll show on this point. in the sense that, my lord, by merely saying that negotiations took place or by stating that the contract was concluded in Kolkata, that does not give any rise to any cause of action. Lord, this is 2007-11 Supreme Court cases 335. কি বলছো? Sir. But would take para 8 of the judgment first. The appellant, my lord, has it. It is in, my lord, internal page 5.
The appellant company.
The appellant company contended that a part of cause of action had arisen within the territorial jurisdiction of the High Court of Punjab and Haryana. The appellant company for such submission relied on the following facts. The appellant company has its registered and corporate office at Chandigarh. The appellant company carries on business at Chandigarh. The offer of the appellant company was accepted on 20th February 2004 and the acceptance was communicated to it at Chandigarh. Part performance of the entire contract took place at Chandigarh inasmuch as rupees 4.5 crores had been deposited by the appellant company in a fixed deposit at Chandigarh as per the request of the first respondent. 5. The chairman and managing director of the first respondent visited Chandigarh to ascertain the bona fides of the appellant company. Now, my lord would see 6. Negotiations were held between the parties in the 3rd week of March 2005 at Chandigarh. 8. Letter of revocation dated 23rd of February 2006 was received by the appellant company at Chandigarh. Consequences of the revocation ensued at Chandigarh, by which the companies agreed. It was therefore submitted that at least a part of cause of action had certainly arisen within the territorial jurisdiction of the High Court of Punjab and Haryana, and hence it had jurisdiction to entertain the present petition. Now your lordship would come to the adjudication that is made by the Honorable Court. My lord would come to paragraph 19. My lord, it is internal page 9. Yes. The question for our consideration is as to whether the assertion of the appellant is well founded that a part of cause of action can be said to have arisen within the territorial jurisdiction of the High Court of Punjab and Haryana. Whereas the appellant company submits that a part of cause of action has arisen within the territorial jurisdiction of that court, the respondents contend otherwise. It may be stated that the expression of cause of action has neither been defined in the Constitution nor in the Code of Civil Procedure 1908. It may, however, be described as a bundle of essential facts necessary for the plaintiff to prove before he can succeed. But this is the test. It is a fact which is required to be proved. Failure to prove such facts would give the defendant a right to a judgment in his favor. Cause of action thus gives occasion for and forms the foundation of the suit. The classic definition of the expression cause of action is found in Cook versus Gill, wherein Lord Brett observed, cause of action means every fact which it would be necessary for the plaintiff to prove if traversed in order to support his right to judgment of the court. For every action, there has to be a cause of action. If there is no cause of action, the plaint or petition has to be dismissed. Mr. Such and Such, senior advocate appearing for the appellant company, placed strong reliance on ABC Laminate versus AP agencies and submitted that the High Court had committed a grave error of law and of jurisdiction in holding that no part of cause of action could be said to have arisen within the territorial jurisdiction of High Court at Punjab and Haryana. He particularly referred to the following observations. That is not relevant. Your Lordship would come to para 24. In our opinion, the High Court was wholly justified in upholding the preliminary objection raised by the respondents and in dismissing the petition on the ground of want of territorial jurisdiction. The learned counsel for the respondents referred to several decisions of the court and submitted that whether a particular fact constitutes a cause of action or not must be decided on the basis of the facts and circumstances of each case. In our judgment, the test is whether a particular fact are of substance and can be said to be material, integral, or essential part of the list between the parties. If it is, it forms a part of the cause of action. If it is not, it does not form a part of the cause of action. It is also well settled that in determining the question, the substance of the matter and not the form thereof has to be considered. Now, my lord, multiple decisions are cited, my lord, where the principles are laid down. And my lord, what I want to show, my lord, is paragraph 33, which is critical. Now, in fact, my lord, takes 37. That is the, my lord, ratio. From the aforesaid decisions and keeping in view the ratio laid down in a catena of decisions by this court, it is clear that for the purpose of deciding whether facts averred by the appellant petitioner would or would not constitute a part of cause of action, one has to consider whether such fact constitutes a material, essential, or integral part of the cause of action. It is no doubt true that even if a small fraction of the cause of action arises within the jurisdiction of the court would have territorial jurisdiction to entertain the suit petition. Nevertheless, it must be, and within inverted commas, a part of cause of action, nothing less than that. In the present case, now, this is important because they also pleaded negotiations. In the present case, the facts which have been pleaded by the appellant company in our judgment cannot said to be essential, integral, or material facts so as to constitute a part of cause of action. So that is exactly my submission before your lordship. Even assuming that what he is saying is true, that negotiations took place at Lord Sinha Road within your lordship's jurisdiction. That is not a fact which is required to be proved or disproved for the adjudication of the arbitration. It is not a part of the cause of action. So that he cannot today rely on that to create jurisdiction of this honorable court. Now, my lord, the question that fell from your lordship as to the usage of the word Kolkata. Now, my lord, in that regard, I have twofold submissions. My first limb of submission is, by mere usage of the word Kolkata, that does not mean the Honorable High Court at Kolkata. Because, my lord, there are as far as 4 civil courts which exercise jurisdiction within the metropolitan area of Kolkata. Now, my lord, for this proposition, my lord, I had cited 2 judgments before your lordship, my lord. I believe, my lord, they are in the record. If necessary, my lord, I'll hand it up again. But the first is, my lord, copy. My lord, should I just hand it up? Sunil, I take the Sir, target the theme. আমি দিয়ে দিচ্ছি আরেকটা কপি আছে আছে আচ্ছা Now, your lordship would recollect the arbitration clause in this particular case, my lord, as my learned senior submitted, says that the seat of arbitration shall be Kolkata. Now, my lord, this is the interpretation of the word usage of such words by this honorable court, my lord, by a coordinate bench. The lordship would kindly turn to page 2 of the judgment. The petitioner refers to clause 2.2 of the agreement appearing at page 48 of the petition. It is necessary to notice such clause. The contract shall be governed by the law for time being in force in the Republic of India. The civil court having original civil jurisdiction at, my lord, would not look into the, at Delhi for PSNR not relevant, at Kolkata for PSER. But that was the language used. Shall alone have exclusive jurisdiction in regard to all claims in respect of the contract. No other civil court shall have jurisdiction in case of any dispute under this contract. Now, my lord, sees the adjudication. The forum selection clause appears to be flawed and in any event vague. The Calcutta High Court has not been named in the forum selection clause as it refers to civil court having original civil jurisdiction. There are several civil courts within the metropolitan area going by the name of Kolkata, which exercise original civil jurisdiction. For a forum selection clause to be effective, the exclusivity of the identified court must be spelled out in the clause itself. Again, it is elementary that a court which does not have the jurisdiction to entertain a dispute cannot be conferred jurisdiction solely by the agreement of the parties. It is only such a court that can be identified as the exclusive court that would otherwise have authority to receive a suit covering the disputes between the parties. Since there is no averment in the petition indicating that this court has authority to receive the action, I have just shown your lordship, even in their petition it is missing. And it is evident that the respondent does not carry on business or have any office within the territorial limits of this court. Not here, the respondents have its offices in New Delhi, as I showed yesterday to your lordship. The petition under Section 9 of the Arbitration and Conciliation Act appears to be without basis and carried to an inappropriate. So, my lord, he cannot merely rely on Kolkata to say the Calcutta High Court. If it had to be the Calcutta High Court, the arbitration clause had to spell out the Calcutta High Court. Now, my lord, this is the first judgment, my lord, on this point. Now, the second one. What are they now? What are they? Golden age today. Yeah, this is reported in 2000 and AIR 2020, Kolkata 217. But I would show your lordship first and foremost the objection that was taken, that is recorded in paragraph 17. At the outset, the respondent has raised a preliminary objection with respect to the maintainability of the instant application and the lack of jurisdiction of this honorable court. The respondent contended that the concerned office of the respondent is located in Salt Lake. Well, that is not 24 Parganas. Now your lordship would come to paragraph 33. That is, my lord, internal page 6. Again, the self-same clause is there, Kolkata for PSER. I have checked the address of 57 Park Street, Kolkata, but no such address has been displayed in the, it should be internet, as the office or business place of the respondent. The petitioner stated that such Park Street address to be the zonal office of the respondent in order to satisfy the requirement of Section 21E1 of the said Act, read with Section 20 of the Code of Civil Procedure 1908. As falsely portrayed in paragraph 35 of the petition, so as to create the jurisdiction of this honorable court. Now your lordship sees this is the test. The scope and purport of Section 21E of the said Act, read with the letters patent for the High Court of Judicature at Fort William in Bengal, 1865, hereinafter referred to as the letters patent, confers ordinary original civil jurisdiction to this honorable court for entertaining applications under Section 9 of the Act only if, now my lord would see, the seat of arbitration is within the ordinary original civil jurisdiction of the Honorable High Court at Calcutta in terms of the letters patent for the High Court of Judicature in Fort William in Bengal, with either 1. The respondent resides / carries on business within the original civil jurisdiction. Does not. The cause of action or a part thereof arising within the ordinary original civil jurisdiction of the Honorable High Court at Kolkata, I have just shown your lordship, does not. Or the parties have exclusively chosen this honorable court. They have not. They have just said Kolkata as their court of exclusive jurisdiction, again with either one, the respondent resides / carries on business within the ordinary original civil jurisdiction, does not, or two, the cause of action or a part thereof arising. So, my lord, again, the tests that are being followed by this court for entertaining applications under part 1 and to act as a 2-1 e-court, my lord, again is not satisfied. This is the test.
Yes.
Harji. And not this was the last judgment I had showed on the last occasion, but just for the purposes of recapitulating, my lord, I am just showing your lordship, my lord, or my lord, I'll just indicate the paragraphs because the self-same propositions have been considered. Lord, this is 2023 SEC Online, Calcutta 2734. My lord, would take paragraph 11. My lord has para 11?
Yes.
Harji, sir. The first issue which needs to be clarified in respect of the arbitration agreement is on the generalized term Kolkata as used in the arbitration clause both in the amended GCC as well as the work order. This is relevant since under the Commercial Courts Act 2015, there are at least 2 commercial courts in within inverted commas Kolkata and a total of 4 courts within the territorial jurisdiction of Kolkata. This would be clear from sections 3, 4 and 5 of the 2015 Act, which empowers the state government in consultation with the concerned high courts to constitute such number of commercial courts at the district level as may be necessary for the purpose of exercising the powers conferred on those courts under the Act. Section 3 covers commercial courts at the district level at the level of the district judge as well as the high courts having ordinary original civil jurisdiction. Hence, Kolkata in the arbitration agreement is found to be used in a vague and generalized manner. This was also noticed by a coordinate bench. Well, I've just shown your lordship that judgment in Sunil High Tech, where the court found such generalized clauses to be flawed for the purposes of designating the court with jurisdiction. It must, however, be mentioned that the comment of vagueness was made on the unamended clause 2.2 before they changed to the present form and made subject to clause 2.21.1. This court also took a similar view in Shrey Equipment Finance Limited. This was the judgment that was cited by my learned senior. This court is therefore of the view that, again, my lord, this is the test. The arbitration clause must spell out the exclusivity of the identified designated court for the purposes of conferring jurisdiction. But that is not there.
Yes.
And my lord, the last judgment I just wanted to show your lordship, which deals with my lord, the judgments that have been cited by my learned senior in the sense, my lord, BGS Soma, Balco. Now, my lord would kindly recollect Balco. My lord, the Balco judgment, my lord, came.
So, who had filed the section 11? You had filed the section?
They had filed the section.
You had filed it?
They had.
Yes. You filed a review to that?
I filed a review to that.
Right?
Right.
The review also, the issue of territorial jurisdiction was taken?
Yes. But that was vis-a-vis, my lord, section 11. Because, my lord, as I submitted at the outset for the entire.
Why didn't you challenge the section 11?
No, my lord, we did not challenge the section 11, my lord. I
so
cannot
you accepted the arbitration here?
Yes. Because, my lord, in my most respectful submission, for the entire territory of Kolkata, that is for the 4 courts within Kolkata.
So, what is your objection today? That
my lord,
go to which court?
Yes. But my objection.
What is your objection in 29A, sir?
Yes. But my objection to 29A is this.
What? That Kolkata is not the
this
court.
This Calcutta High Court for the purposes of 29A does not satisfy the test.
Where should they go? They should go to Rajarat.
But in my most respectful submission, they have designed the arbitration clause because it's their document.
No, according to you,
but they are under a legal disability. I must be candid before your lordship.
No.
They do not have a forum for the 29A. because they drafted.
They don't have a forum.
Yes, but they are without a forum. Because I'll be very candid with your lordship. They have designed the arbitration clause in such a manner that for an entire transaction that takes place in New Delhi, they have chosen a vague and generalized clause.
So you should have challenged that 11-6 order.
No, my lord, the question of
You should have
challenge.
gone to the Supreme Court, get it set aside.
No, my lord, in my most respectful submission.
You have accepted the tribunal.
My lord,
You are
I have
participating. Today we
have
are only in
accepted the
29A.
My lord, I have
This is
accepted
only for extension of the mandate.
for the I have
You
accepted.
are arguing as if you are challenging the 11-6 order.
No, my lord, I am not.
Then
I'm not
this
at
is
all
only
arguing.
extension.
But in my most respectful submission, in order for your lordship to pass an order under section 29A, your lordship must be the section 21E court, and thus that must be borne out from the facts of the case. That is not borne out. And my lord, the first order of this court itself records that this issue is not res judicata. Now, my lord would take paragraph 36 onwards. My lord has 36.
So according to you, which is the 21E court?
But according to me, again, my lord, as your lordship, my lord, I said before, they are under a legal
Which
discipline.
is the 21E
My
court?
lord, there is no court within the entirety of Kolkata which is the 21E court. That is borne out from the facts of the case, because there is no part of the cause of action which is arisen within Kolkata. My lord, and as my lord, the first judgment says, the parties cannot confer jurisdiction upon a court which does not have inherent lack of jurisdiction. And my lord, again, that principle is repeated here. That is why I wanted my lord to finish with this. In Indus Mobile Distribution Private Limited, the court referred to and relied upon the dictum of a constitution bench of this court in Bharat Aluminium Company, that is Balco, that is cited by my learned senior, versus Kaiser Aluminium, and held that once the seat of arbitration has been fixed, that would be in the nature of exclusive jurisdiction clause, binding the parties to specific courts which alone would exercise supervisory powers over the arbitration. In Balco, that was the issue before the constitution bench. What was the meaning of the expression place of arbitration in the context of section 2, subsection 2 of the Arbitration Act, which is amended by Act 33 of 2019, is set out herein below. Now, my lord, sees para 37. The questions before the constitution bench was whether of part 1 of the Arbitration Act applied to arbitration where the place of arbitration was outside of India. As observed by the constitution bench, section 2 of the Arbitration Act places a threshold limitation on the applicability of part 1 where the place of arbitration is not in India. The constitution bench in effect and substance drew a distinction between venue and place of arbitration as contemplated in section 20 and held that only if the agreement of the parties was constituted to provide for seat/place of arbitration in India would part 1 of the 1996 Act be applicable. If the seat place were outside India, part 1 would not apply, even though the venue of a few sittings may have been held in India or the cause of action may have arisen in India. The judgment of this court in BGS Soma JV, cited by Mr. Such and Such, was also rendered in the context of section 2.2 of the Arbitration and Conciliation Act and the applicability of part 1 of the Arbitration Act to an international commercial arbitration where the seat of arbitration was not in India. And then your lordship would take paragraph 47. It is well settled that when 2 or more courts have jurisdiction to adjudicate disputes arising out of an arbitration agreement, the parties might, by agreement, decide to refer all disputes to any one court to the exclusion of all other courts which may otherwise have had jurisdiction to decide the disputes. Now, this is the point which would address your lordship's query. The parties cannot, however, by consent, confer jurisdiction on a court which inherently lacked jurisdiction. That is my most respectful submission before your lordship. And my lord would see the arbitration clause here that is there in paragraph 3. Again, the word Kolkata has been used. So, my lord, these are my most respectful submissions, my lord, before you.
My lord, to cut short the matter, my lord, kindly sees, my lord, he has accepted then, my lord, that this honorable court is the superintendent court exercising jurisdiction over the 2-1E court. That he has accepted. Because that is attended finality, my lord. He has not preferred any appeal before the Supreme Court. So there has to be one court in West Bengal over which this honorable court exercised jurisdiction under Section 11. Now he says, my lord, to cut short the entire thing, I'll just, my lord, in few minutes, I'll, my lord, distinguish his judgments also, my lord, is that there is a 2-1E court he accepts, which has got jurisdiction. So lordship rightly asks, which is the 2-1E court? Now he's saying, I don't know, there is a flaw in the agreement. That can't be, because there has to be a 2-1E court, because he has not, my lord, got the Section 11 set aside. This argument would have been fabulous had he got it set aside. Now, my lord, let us take his highest case. He is saying that there are many courts under the definition of Kolkata which will exercise jurisdiction as 2-1E court. Let us accept that. Now, my lord, only comes to one document which he has not addressed correctly because he cannot. My lord, kindly takes the supplementary affidavit and kindly comes to page 26.
Yes.
Well, therefore, he has said that there are many courts which can become 2-1E courts. Now, kindly sees, my lord, only this court will have jurisdiction. Why? Because the claim is above 2 crores. Admittedly, kindly comes to B, my lord. My lord, I am reading from the top. In exercise of the power conferred upon 1A of Section 3 of the Commercial Courts Act 2015 as subsequently amended, then, my lord, kindly sees, February 20 is pleased hereby to specify with immediate effect the pecuniary jurisdiction in terms of the value of the commercial disputes as mentioned. In case of commercial courts at Shiliguri, Asansol, Alipur and Rajarhat, an amount not less than rupees 30 lakhs. In case of commercial courts within the territorial jurisdiction of the City Civil Court of Calcutta, of an amount not less than rupees 3 lakh and not more than rupees 10 lakh exclusivity. Kindly mark, my lord, the word exclusivity. This is with regard to City Civil Court. So if my claim was below 10 lakhs, City Civil Court was the 2-1E court. Then, my lord, kindly sees, and exceeding rupees 10 lakh but not exceeding rupees 1 crore concurrent with commercial division of the High Court, and above rupees 1 crore is lordship. So, my lord, it puts an end. Lordship is the 2-1E court. And lordship will now see all his judgments, my lord. Kindly takes all his judgments. I need to show the cause title, my lord. Need not take into the facts of the case. My lord, the first judgment is showed of Justice Shonjib Banerjee. Kindly sees, my lord, the cause title.
Yes.
AP number 9. This is not a commercial division matter. I need not show the facts. Facts also can be distinguished, but I do not want to waste my lord's time. Next judgment he showed, my lord, is, my lord, Golden Age, I think. Kindly takes that judgment even, my lord. That's, my lord, the next judgment. My lord, that's, my lord, kindly sees the cause title again. AP number 191, not a commercial division matter, my lord. Lordship has got it, my lord. Then, my lord, the next judgment that he showed, my lord, Harji. That's also, my lord, 2023 SCC online of Justice Bhattacharya. Kindly sees AP number 474 of 2023, not a commercial court matter, my lord. Commercial division matter. Then, my lord, kindly sees, my lord, the last judgment, my lord, I need not distinguish even, because that says, my lord, the choice is with the parties, my lord. It can go to the court where they have decided in terms of the agreement. Otherwise, if the court does not have, that is different. But, my lord, that's not the case. He says that this court does not have. Some other 2-1E court has. But, my lord, the notification says, my lord, that this court will only have, because the claim is more than 2 crores, my lord. And all these are, my lord, APs are, my lord, non-commercial matters. So, my lord, my lord, can distinguish each of these, my lord, judgments on the face of it, because, my lord, kindly sees the judgments, my lord, they do not spell out, my lord, that, my lord, where the arbitration would be. Parties by choice chose Kolkata. That is not in dispute. Part cause of action has a reason. Now, my lord, lordship has to see, taking his argument even. Lordship is the only exclusive court under 2 because of the claim being more than rupees 1 crore. And my lord, my learned friend has not, my lord, once said that the claim is less than 1 crore. And also that the superintending court is this honorable high court, that is also he cannot dispute. So there has to be 1 court before under the superintending court. And this is the only court, my lord. So, my lord, to cut short, my lord, kindly, my lord, I can file a notes even if your lordship wants. Otherwise, my lord, kindly, my lord, extends the time. We are, my lord, at the stage of, my lord, having, my lord, evidence, I believe. Evidence hoega che? Our evidence is over. And, my lord, we will be proceeding, my lord, with the, my lord, rest. I think his evidence would be initiated, my lord. So, my lord, this is the short thing. Kindly looks into this notification, my lord. Lordship is the only 2 court.
Just, my lord, two things. Your lordship would look into the notification and the next page. I had already shown it to your lordship. Page 27. That is the clarification on the notification. And, my lord, I would, my lord, beseech your lordship, my lord, to check from the registry from which date the commercial numbering, my lord, came into existence. That is all. I believe, my lord, it was 2024.
My lord, kindly,
Subject to correction.
kindly
Because
takes
these
the
are
next
discrete
page.
matters.
My lord, kindly takes, my lord, the next page even, my lord.
Yes.
Kindly sees, my lord, the local limits of the jurisdiction of the commercial court. The area is included within the ordinary jurisdiction. My lord, I don't think, my lord, my learned friend is disputing that my lord, offices are within jurisdiction.
Absolutely, I am disputing that. His office is irrelevant.
My office is
I
within
am the
jurisdiction because
respondent.
part cause of action has a reason. My lord, I am not on the respondents, my lord. It's part cause of action. Part cause of action has a reason, and therefore lordship has got more than, my lord, the pecuniary jurisdiction. Those are my submissions.
Part cause of actions, I have already made my submission. But may I just file a very short note for your lordship's convenience, because we have argued the matter in a staggered basis.
I don't need it.
Very well then, not required.
Grateful, deeply obliged.
Grateful to your lordship. I'm grateful to your lordship.
Yeah, the 2-1.
Someone has to be.
My lord, both the matters 14 and 15.
14 and 15 are
Same
answer.
answer.
14, 14, 15. These are separate matters or?
Separate matter, my lord. I think two arbitrators. Separate section 11, two arbitrators.
The operative arbitration clause, my lord, is the same in both.
Two separate. I'll come back.
No, item number 8, my lord, I appear for the respondent. The whole difficulty is, my lord, I have been served through email, but I could not obtain. No, objection, my lord, sufficient causes are not there. Because, my lord, they are the claimant, my lord, in the arbitration proceedings. My lord,
My petition.
at the evidence stage, my lord, my lord, it is for extension of the, my lord, the mandate. My lord. No, my lord. No, my lord. But, my lord, kindly look at their conduct, my lord, in the arbitration proceeding. My lord. But only thing, my lord, I could not, my lord, obtain the, my lord, Bhokaladnama, because, my lord, the company situated at Hyderabad, my lord. One of the officer has to, my lord, come down from Hyderabad, my lord. But then, my lord, kindly give some time, my lord. Filing the Bhokaladnama. Because, my lord, for that, my lord, because my lord is taking up the matter, my lord, and disposing of. Lordship can leave, my lord, to find. I leave it to your lordship.
কোন স্টেজে আছে?
Sorry, my lord. Sorry, my lord. I was, my lord, another court. Sorry. Well, sorry.
Oh, this is a, my lord, section 29A application, wherein, my lord, an amendment application is pending. They have filed an opposition, hearing will take place, my lord. So, my lord, it has to be extended till such time, my lord. And they have not filed any section 16 before the arbitrator also, challenging his jurisdiction or anything, my lord. My lord, the arbitrator was appointed, my lord, by the section 21 notice on 13th of October 2023. But, my lord, thereafter, the company went into, my lord, CIRP, and, my lord, the changes took place, and it is only in 2024, no? 2024 that the new management came in, my lord. And, my lord, proceedings from then onwards have been continuing. My lord, it is contested. Every day it is contested. My lord, my learned friend is appearing in the arbitration proceedings, and it is not an uncontested matter, my lord. And there is an application for amendment which has been filed. He has filed an opposition to it, and at this stage it is pending, my lord.
My lord, they filed, my lord, the affidavit, my lord, of evidence, my lord. At that time, my lord, they did not say, my lord, that the original agreement on which basis this arbitration proceeding. My lord, I have taken the defense, my lord.
My lord, the last minutes is at page 30, my lord. Lordship will find, my lord.
No. And only with regard to the conduct.
He has taken these points in his opposition, my lord, which he has filed, my lord, to my amendment application. কোনটা আগে? এটা আগে না? No, no, my lord. This is by section 21. He has not opposed the appointment, my lord. My lord, the amendment application has been filed on, my lord, 6/11/2025, my lord. And he has filed his opposition on 14/11 and 21st, my lord. Notice of motion. এই first ম্যাটারটা এটা পরেরটার তারপরেরটা এটা এতগুলো কেন এটা তারপরেরটা my lord, I think tooth and nail fight, my lord, will take 1 year, my lord. I think, my lord, from this date. 8 months. Date.
My lord, only one thing, my lord, not to give any unnecessary adjournments. At the evidence stage,
Yes,
they
yes,
have
of
taken
course,
not
of course.
eight adjournments.
Yes, yes, my lord, of course, my lord.
Not to give any unnecessary adjournments.
ঠিক আছে সেটা লিখতেই পারে
We have not taken any adjournment, my lord.
my lord, the next 3 matters also identical, only, my lord, the cost title is different and my learned friend is also on the other side. Leave to file the same date of appointment is the same, last minutes also same.
My lord, leave kindly, my lord, to file the Bhogalanam in the month of registry, my lord.
না ওটা লিভটা নিয়ে নাও না তো ফাইল করতে পারবো গ্রেটফুল ম্যাম লিভ এটা কত অবধি 11 till 11 my lord same order same identical orders great
Lordship, in this matter, I had to file an affidavit in reply. I have already served.
Your Lordship, we have received the affidavit in reply only yesterday evening. I'm seeking an accommodation. Your Lordship, I come back with. With,
11th March.
with your honesty.
11th month, 10th month. Lordship, in this matter, on the last occasion, the respondent had given us a letter which was placed before your Lordship, where they have said that they want to make payments. Lordship, on 2nd of February 2026, Lordship had given us another 2 weeks' time to explore the possibility of amicable settlement. Lordship, we have served that upon them. Lordship, today in the morning, they have sent us this letter where they're again asking for time to make the payment, and they're saying that they will make the payment of rupees 3.22 lakhs within 25th of March 2026. Lordship, this is the letter that they have given. Lordship, Lordship, I will be praying for an injunction on their bank accounts because they have been delaying the payments. Lordship have given them ample time to make the payments, but they have been delaying it. The only payments that we have received is given in the letter itself that they have given us in paragraph number 7, which is a payment in 15th November, on 15th November, thereafter 31st January. This is the payment that we have received. Lordship, that is a wrong statement. After they have made payments, Lordship, what we had claimed, Lordship, we had claimed 18 lakhs and odd, out of which they have made payments of near about 2 lakhs. Lordship, they are not taking the interest amount, not the check bouncing amount. Nothing has been taken. They are just taking the pure installment amount, and that's what they are saying. Lordship, in that case, Lordship extends the time to make them the payment, whatever they're saying. Substitution, unless it's not. Where is the chart made in this? Yeah. Lordship, this is my Section 9 application. Lordship, initially, the respondents in this matter had appeared on 5th of January 2026 and had prayed to file an affidavit of opposition. Lordship, thereafter, they had not filed an opposition and Lordship had directed us to serve upon them. We had served on the advocate who had been appearing for them. Lordship thereafter directed to serve on the respondents directly by an order dated 4th February. Lordship, that we have done. They have received the letter on 10th of February. The opposition is not there, Lordship, on record as on date. They have not filed anything. Lordship, I was praying for an injunction on their bank accounts. Lordship had recorded the facts of the case on 25th November 2025. এর আগেরটা কবে দিতে হবে? First. Yes, Lordship. Online dispute. No, no. Yes, Lordship. Lordship, bank details are given in page 49. It's Punjab National Bank and one Axis Bank.
Your Lordship, I'm for the petitioner leave be given to file a affidavit in reply on behalf of the petitioner. Your Lordship, on the last occasion, there was a 2 weeks time. I was late little bit.
My lord, I am for the respondent, my lord. My lord, I pray for 2 weeks time for to fix this matter for hearing, my lord. My lord, I have not yet received the reply, my lord. No, my lord.
Your Lordship, I'm giving that reply.
Obliged, my lord.
Your Lordship. Which appearing the
But I am for the respondent. Section 9 application, but during pendency of this application, Lord, the Honorable High Court has appointed an arbitrator in the Section 11 application on 3rd February. We have already filed the Section 17 before the arbitrator. My Lord.
Section 70. It.
Already filed.
21st. Copy also served in the response.
Obliged.
Yep.
17 I have filed before the land. No, I submitted
21st.
on 21st.
21st, and copy served upon them yesterday. Mm-hmm. 25 copies served upon them. Yes, problem.
But serial 21 is my application under section 9. But I have just received instruction that there are talks of settlement going between the parties. So I was humbly praying, my lord, if this matter can be posted in the month of April, by which, my lord, in all likelihood, there'll be a settlement between the parties. Sorry. But 8 weeks. Deeply obliged. Lord, serial 22 also, my lord, I am appearing for the petitioner. My lord, your lordship's last direction was to serve upon the respondent number 4. Lord, I have duly served upon the respondent number 4, and all the respondents have been served, and this is for respondent number 4. The other, my lord, the one which before your lordship is for respondents 1 to 3. Lord, my application under section 9, my lord, where I'm paying for certain ad interim orders, my lord, only to the extent of securing the amount in dispute, which, my lord, I'll disclose ex facie from the documents that the respondents had availed of a channel finance facility back in the year, my lord, before 2020. Time and again, the facility was renewed. My lord, the last renewal happened on November 2023 for a sum of rupees 3 crores. My lord, the renewal letter is at page 39 of my petition. Yes, Lord. Lord, kindly comes to my lord, page 54 of my petition. Now, this is the main agreement. My lord, the date is, my lord, 23rd of November 2023. Lord, the terms and conditions are contained in this agreement, and the details of this loan agreement, my lord, starts from the schedule to this particular agreement, which is at page 60. My lord. Page 60 is the schedule, my lord, which contains the date, which is 23rd of November 2023. My lord, at page 60, my lord, page 60, my lord, at the bottom. My lord, at page 63, my lord, serial number 5 is the sanctioned amount, which is stated. At page 63, serial number 5. My lord, 3 crores, my lord. Lord, the purpose, my lord, as it would be evident from the schedule at serial number 6, my lord, I'll take your lordships thereafter to the sanction letter. But the purpose, the tenure of the loan, the details are also stated in the sanction letter. So, my lord, this agreement and the sanction letter, my lord, together constitutes to be a single contract, and the understanding under which this particular loan was, my lord, sanctioned. It was, my lord, admittedly accepted and received by the respondents. My lord, the sanction letter, Lord, may I just draw your lordship's attention just to the terms of the sanction letter, which is at page 48. Lord, prior to this particular agreement on 23rd of November is the sanction letter dated 15th of November 2023. Lord, the facility details is stated. It's a channel finance facility wherein, my lord, this entire financed amount was to be used by the borrower to procure, my lord, goods from, my lord, Tata Motors Limited, which is my sister concern. So in order to facilitate the purchase of the goods, this particular amount was sanctioned. My lord, this is called the channel finance facility. My lord. The Lord, at the loan sanctioned amount is stated, and the date within which the payment has to be made is also stated here, which is the tenure of the tranche, which is 90 days from the date of disbursement. And at next page, my lord, at page 49 is the, my lord, the details of the manufacturer from which the goods were to be procured and against which this sanction, the amount of 3 crores was sanctioned, my lord. The name of the distributor is also stated. So from the date of, my lord, disbursement, within 90 days, my lord, he had to repay this particular amount, and he had the maximum sanction of rupees 3 crores, my lord, for a period of 1 year. But this was disbursed to him. There is no dispute to this fact. It was received by him. But what thereafter it transpired, my lord, that 2023 was the date of sanction. My lord, till 2025, there barely have been any payments which has been made by the respondents. Because the contract, if your lordship sees the agreement at page Lord 54, the agreement, my lord, contained a repayment clause at clause 3 at page 54. And there are, my lord, other conditions which were also supposed to be fulfilled, my lord, at page 56 by the said borrowers, where he had to, my lord, ensure that the agreement has been complied in its entirety, not the repayment. Now, what the respondents did, what, my lord, they have received the money, they have failed to repay this loan. So the petitioner, my lord, was thereafter compelled, my lord, to terminate the loan facility and recall the entire amount. That termination letter is at page 67 of my petition. It's a letter dated 7th of May 2025. My lord, addressed to all the respondents. And at paragraph 9 at page 71, in fact, my lord, paragraph 10 and 11, it's wrongly written as 9, but it should be, my lord, 11, 10 and 11. My lord, the agreement was terminated and they were called upon to pay the entire amount of rupees 2 crore 59 lakhs, which at that point of time, my lord, remained due and payable. My lord, immediately thereafter, my lord, we filed this petition under section 9, my lord, because the fact that on the first dates, my lord, this service could not be completed, my lord. We could not on that date, my lord, press for an ad interim order. But the fact remains, my lord, ex facie that they have received this money and they have ex facie, my lord, failed to repay this money, which was payable under this loan agreement. My lord, considering the fact that the petitioner will, my lord, initiate arbitration proceedings, lord, I was only humbly praying, my lord, that the interest of the, my lord, the subject matter of this dispute, my lord, be secured. Because what we have also learned, and I've pleaded specifically, my lord, at paragraph 26 and paragraph 30 of my petition. My lord, paragraph 26 and paragraph 30, where I have come to learn, my lord, my lord, so far as the property defined at paragraph 26, this was mortgaged, my lord, against this particular property, my lord, against this particular loan. So far as paragraph 26, the details of the property that I have stated. And at paragraph 30, my lord, I have also come to learn that there are other assets of the respondents, which are in the name of the respondents, plots of lands. My lord, cumulatively, my lord, all will value, my lord, more than approximately 1.5 crores. So I was humbly praying, my lord, till the time the proceedings, my lord, I go before the arbitrator and the arbitrator takes cognizance of this matter, my lord, let there be an order of injunction only in respect of these assets, that they should not deal with these assets in the meantime, so that, my lord, my efforts to, my lord, recover this due, my lord, do not become infructuous. But so far as the jurisdiction is concerned, my lord, one more fact, my lord, I should have pointed out. It is specified under the agreement as Kolkata, my lord. But the arbitration clause specifies the venue and seat as Kolkata. Lord, the arbitration clause is the Lordship takes, it's a part of my loan agreement, my Lord, at page 56, clause 12. On the second last line, it reads that the same shall be settled by arbitration by the sole arbitrator to be appointed as per the procedure and to be held at such place as agreed in serial 17 of annexure 1 of the agreement. Now, my Lord, serial 17 is there at page 65, which is, my Lord, the annexure 1 is prescribed as Kolkata. The venue of the proceeding is as Kolkata. And there's also a jurisdiction clause, my Lord, clause 13 at page 57, which also prescribes Kolkata to be the place, my Lord, where parties consciously agreed to confer jurisdiction in Kolkata. And the loan was also, my Lord, facilitated from the branch office of the, my Lord, petitioner. But, my Lord, Kolkata was agreed specifically under the contract, my Lord, to be the place where parties, my Lord, will confer jurisdiction. My Lord, my prayers are at page 24. And I'm only praying for an order of injunction, my Lord, in terms of prayer B. That they should not deal with it, my Lord. I really do not know. Their conduct as of now reveals that there is every likelihood that they will deal with these assets, because despite receiving, my Lord, notices time and again, they have neither responded to my termination notice, neither they have thought it appropriate to come and participate or make any representation before this court. Execution, jurisdiction. Yes, my Lord, schedule. Nothing, my Lord, only an order of injunction. Protect the subject matter of my claim. Not bank account, not. তুমি আমায় প্রপার্টি বলেছিলে, আমি বলে দিলাম না। But it's 2.59 crores, my Lord, as on 3 crores, my Lord. My Lord, 23rd of November 2023. 2023. Right, it was extended, but this is, my Lord, the first agreement will be, my Lord, around, my Lord, 2018, my Lord, 4th of December 2008. My lord, the last sanction limit, my lord, was 3 crores. My lord, that was the last agreement. I should have mentioned it, my lord. Initially, Lord, may I just state one fact, my lord? Lord, 2008, because this agreement, my lord, superseded all other agreements. This was the final agreement, my lord, which superseded all other agreements, my lord. But which is why, my lord, we have just pleaded it, not. I'll come back, my lord, to go. This, my lord, this is an agreement, my lord, which has superseded, my lord, all the prior agreements. I should have, my lord. I should have, my lord. I'll come with a list of dates tomorrow with your lordship. Well, actually, my entire cause of action was outside of the agreement on 2023. But those agreement already, my lord, stood concluded. Man. This is the fresh agreement, my lord. Which is why we have not even annexed those documents because only the 23 agreement. No, this is the memorandum of my lord, the mortgage for deposit of title deed. I should have, my lord. I apologize, my lord.
Somebody will give you document without any basis. Give back the affidavits. Not today. And please do your homework well. Don't force us to do things. Next.
Grateful.
This is my Section 9 application. But you will remember, my lord, I was seeking for an interim order where, my lord, I was a shareholder, my lord, in the private limited company, which was transformed into an LLP, my lord. And within days, my lord, I was ousted by forgery. And then, my lord, I find that they have told, my lord, the land to some developer and they are developing it. So, my lord, there were serious issues of fraud, and then they said that they have paid me. So that is on merits I'll deal with. But kindly sees the conduct, my lord, 28th January 2026, lordship gave them time for 2 weeks to file their affidavit in opposition. Reply, if any, within 1 week, so that we can come back today before my lord. But to my lord, to take a direction and then, my lord, not to comply with it, my lord, expired on
Lordship,
12th
with
of
some
February.
trepidation and with great utmost humility, I'm submitting. This is fundamentally ready. What is left is the execution of it, because there are multiple respondents. We require 3 to 4 days time, your lordship, would be enough for this to be executed, affirmed, and placed on record, your
Why
lordship.
should I take it? Like, I should pass an order right in favor of them. Forget about your affidavits. You have failed to file an affidavit. Why should I take it?
Your lord,
we are dependent on your people. That you will go and get their signatures. This is the way you treat the order of the court.
not at all, your lordship.
Why you have not filed it?
We are getting them, all of them,
Sir,
to sign it.
Concerned.
We just need 3 more days, your lordship.
I will give you 24 hours and not more than that.
It may be 48, your lordship.
I will not give you any time.
No, okay. 24 hours, we bow down to your lordship. We bow down to your lordship, but if a little bit, that's all I would.
I have given you 2 weeks time.
Yes, your
Comply with the
lordship.
order of the court.
On that account, we stand humble, your lordship. On that account, we stand humble.
We are not concerned by your
Yes.
people. Not today.
My lord, in that case, if he files it by today, my lord, I'll take 2 days to give a rejoinder because it's, I'm
24 hours,
sure
your
he
lordship was pleased.
keeps it on, my lord, Thursday,
Learned
Friday.
counsel for the respondent seeks and is granted further time of 1 week to file his affidavit in opposition. reply to the same, if any, within 1 week thereafter, list after 2 weeks. 2 weeks will take us to
2 weeks
Sir,
will take
time
us to
will
your
not make it
lordship
2 weeks.
for-
I'll give it in 2 days, my lord. Lord, I
March
need
10th,
time.
it will come to your lordship almost. March 10th.
March 10th. Yeah.
I'm
Great.
not here only from the 16th.
Yes, my lord.
From 16th, I'll go.
Yes, so lordship will be there, my lord, on March. Grateful. My lord.
Grateful, your lordship.
Considering,
Much
my lord,
obliged.
may it, my lord, retain its position, my lord, since, my lord, it's an interim. Grateful, my lord. Great.
Much obliged. Apologies, your lordship. Much obliged.
Lordship, I was praying if the matter could be kept in abeyance because the Section 8 application, Section 8 application is still pending. It will be heard on 2nd of March. So I'll come
Learned
back
counsel
with the
for
order.
the petitioner states that her Section 8 application is pending consideration before the
Barashat Court.
Barashat Court. She prays for an adjournment. Let this matter be listed in the monthly list of April.
April.
We kindly record one more thing. There is another the dispute regarding about the self-same cause of action. Another Section 9 application.
The Section 9
was
application
filed by
was
him
withdrawn. Lordship, it was withdrawn, but the order has been recorded incorrectly, which is an application has been filed for correction, which is being taken up on 27th February.
Lordship, this is my application.
Lordship, in this matter, Lordship was pleased to direct us to file affidavit in opposition within 4 weeks, Lordship, that we could not file in time. Lordship, may if you, Lordship, may.
Lordship, on 13th of January, the order was passed. 4 weeks time was given to them, Lordship, to file their opposition, and 2 weeks time was given to us to file a reply. They have not filed any opposition till
Kindly,
date,
Lordship,
Lordship.
give us further 2 weeks time, Lordship. We shall.
Not at all. Why should I give you
Kindly,
2 weeks
Lordship.
time?
Shall she say?
Eastern Railway.
Lordship.
Government departments don't function. Huh?
Lordship, that.
Even if I give you 2 weeks, you will not function.
No, Lordship. This time, Lordship, I already communicated to them up to the Lordship, higher authority, Lordship. So they are actually, Lordship, that some facts and figure we need
Lordship,
to
there was
take from the.
Impose cost.
Lordship, I
of
apologize
filing
on behalf of
on-
the department, Lordship. That is their Lordship. That is laches, Lordship. I apologize on behalf of the department. That is laches, Lordship.
You
That
don't
is
want to file, don't file. We'll pass an order.
Lordship, kindly, Lordship, because this is a point, Lordship, need to, Lordship, consider. That was fallen from your Lordship at that time also, Lordship. Kindly, Lordship.
Lordship, there was just that that we did not follow up from 2021 to 25. That was the point that Lordship had asked them if they want to give any opposition. Lordship,
Learned counsel for the respondent seeks and is granted further time of 2 weeks to file.
Lordship, I would require at least 2 weeks time because my client is
Reply to
stationed
the
out.
same, if any, within 2 weeks thereafter. List after 6 weeks.
Grateful, Lordship. Grateful, Lordship.
This is that matter was taken up yesterday. Ask them to whether the award has been.
Yes.
So, my lord, award has not yet been passed, but the loan agreement was made in Chennai. The head office is at Chennai, and the arbitrator was also appointed in Chennai, where the interim order has been passed, my lord. If the new arbitrator is appointed in Kolkata, there will be some difficulty for the bank also, and
This is a unilateral appointment.
yes, my lord, but already an arbitrator has been appointed in.
But it is, even if the arbitrator has been appointed, he has to go. Either you give a consent or we'll decide it.
As per discretion.
That's what I asked you, madam. Get the instruction.
Arbitrator.
Unilateral appointment, it's against the
If
law.
arbitrator is appointed, then it is fair. But if it is in Kolkata, then it will be difficult for the bank because their head office is at Chennai.
What are the, what
And
is the agreement?
loan agreement.
Normal loan agreement.
Loan agreement was also in Chennai, made in Chennai, and the petitioner is residing in
It's all
Darjeeling.
in Chennai.
Yes.
Everything is in Chennai. Then 37 house.
I know. That's why I said in the first beginning itself, if they consent because they filed section 9 here. I am aware. I am aware.
Then you go to Chennai.
Yes, yes, yes.
Learned counsel for the petitioner seeks to withdraw the present petition.
So she will indicate the point. I'll go to Chennai.
Learned counsel for the petitioner states that I'll give you liberty. Seeks to withdraw the present petition since the appropriate court would be the Chennai High Court in terms of the agreement between the parties. Full stop. Liberty is granted to the learned counsel for the petitioner to approach the appropriate jurisdictional court in accordance with law. The present petition stands disposed of.
They take the point of jurisdiction at the same time they file section 9 before your lordships and take
In terms of
orders.
the above observation,
Written.
along with the connected application. The rest of the matters after lunch. 2 बजे Supplement.
Lordship, I appeal on behalf of the award holder in this matter.
I'm appearing on behalf of the judgment data 2, my lord. 2 matters, my lord. Surrender to it.
मैं ये मुकदमों में गवाही के तौर पर जो कुछ बोलूंगा सच बोलूंगा सच के सिवाय झूठ नहीं बोलूंगा कुछ नहीं रोहन माइती yes o ID yes o 82 Maitri son of Rakesh
I'll just
अच्छा फुलेश सर है पोस्ट पे फुलेश सर है
I mean, sir,
When will you make the payment?
गाड़ी हमने सिलेंडर করে দিয়েছিলাম স্যার
गाड़ी सरेंडर कर दिया, पेमेंट तो करोगे आप?
नहीं मेरा गाड़ी जो है वो गाड़ी मेरे नाम पे नहीं था वो बॉडी है मैंने अन्य लोग दूसरे नाम के गाड़ी था
Is guarantor, my lord.
He's the guarantor.
Hi.
Whatever it is, he's the guarantor. He has to make the payment. Why did he become a guarantor? The liability of the guarantor is not there.
Is attached the back hill, my lord.
So what, sir?
My lord, I filed my affidavit asset within week, my lord. Today, in course of today, I filed, but my lord not signed.
Take down.
Affidavit asset filed.
This court by order dated 15 January 2026 had issued the warrant of arrest against award dated number 2. Award dated number 2 has been produced in the court. Warrant of arrest is discharged. Oath has been administered. Award dated number 2, 1 and 2. You appear for both?
My
Award dated number, learned counsel for the award dated number 1 and 2 seeks and is granted 2 weeks time to file his affidavit of asset. Full stop. Award dated number 2 undertakes to file his affidavit of asset within 2 weeks. He further undertakes to appear before this court as and when required.
and may there be a further direction for disclosure of affidavit of assets on behalf of judgment data number 1 as well.
He said that. He's appearing for both of them, right?
My lord.
Oh,
yes.
Grateful.
Placed after 4 weeks.
Check.
The award data number 1 is who? The mother?
Mother, my lord.
Your mother has taken it and you're saying you're only a guarantor.
I'm guarantor.
So ensure the mother pays. Or you will also go, your mother will also go. Next.
Two, my lord.
And same matter.
Same order too. They have taken 2 loans.
2 loans.
Scam.
One has a due of around 31 lakhs, one has a due of around 22 lakhs.
Given the oath at least. That's not true.
আমি
Same
এই
तो है
মামলায়
record
क्या बोलবো
same ही है same
तो
thing
बोलবো
is recorded.
তথ্য ছড়া
Let him give the
মিথ্যে বলবো না কোনো কিছু গোপন করবো না
Wait for lunch.
Lord, I am for the petitioner, my lord.
Yes.
Mr. Substitution is appeared.
My lord, I'm led by Mr.
My lord.
Shorkar.
My lord, this is a matter, Lordship, where this is a Section 9 application where we've obtained an interim order. In the meantime, Lordship, we had filed a Section 11 application. The matter was, the hearing has now been concluded. My lord, we filed our written notes. The matter's been made CAV today. Now, the interim order is expiring tomorrow. Lordship may kindly extend the interim order only for a reasonable period of time till the judgment comes. Because the Section 11 application was a contested matter, Lordship.
My lord, I am appearing for respondent number 1, my lord.
In all likelihood, when do you expect?
3 weeks, my lord.
The interim order granted earlier is extended further for a period. Learned counsel, the petitioner states that the Section 11 application has been heard and the same has been made CAV. The request for the interim order, if the interim order granted earlier is extended further for a period of weeks, list after 4 weeks.
Grateful, Lordship. Much obliged.
List after 4 weeks. Great. हाँ वो कर दो सेक्शन 11 कर दो
My lord, in this matter, by an order dated 4th August 2025, Lordship Justice Shampa Sarkar had passed an interim order restraining the respondents from operating their bank accounts. Thereafter, Lordship had instructed us to initiate the arbitration proceedings. We have issued our 21 notice. Lordship may dispose of the Section 9 application.
Learned counsel for the petitioner states that they are taking steps to. What do you want me to record?
Lordship, that the Section 21 notice has been issued. The arbitration proceeding has been initiated.
Learned counsel for the petitioner states that Section 1 notice has been issued. Arbitration proceedings have been initiated. He no longer wishes to press the Section 9.
No, we do not want to press the Section 9.
He does not wish to press the Section 9 application. The same is dismissed as not pressed.
Sir, it is their Section 9, but arbitrator already appointed.
Maybe I can still pursue.
Can you go before the arbitrator?
Yes.
I can still have a right to be before.
I will not entertain it. Section 17.
No, Section 17, yes, but this is a pending matter.
Still?
Lord, I can still,
No, once the arbitral tribunal has been constituted, you go there.
Lord, I would like to, at least, ask, for reliefs here. There's no point, in going,
Whatever reliefs are, you go ask before the tribunal. I'll refer this as Section 17 if you want.
that is, sometimes it's done, but, there are also judgments, which says that, I can, because this has been filed before.
You want to argue, I can hear you, but I'm not going to grant anything.
Why, my lord? I don't know, my lord.
If you're,
I don't want to be, my lord,
first-
deprived of an opportunity, my lord, to argue here instead of, my lord,
That's not the
going, my
point.
lord.
You get many opportunities, Mr. Banerjee.
No,
You
no,
always have
my
the
lord, I,
opportunity.
my lord, in fact, my lord, will recall, my lord, this matter, my lord, I had moved, my lord, one of those days, and then, my lord, they had, what time is it? They had taken time, my lord, for the purpose. No, no, that's all right. But the fact of the matter is, my lord, the matter was pending. I, my lord, asking for, my lord, interim reliefs.
You go before
Now,
the
my lord,
before the tribunal. Go before the tribunal. If you don't get anything, we'll see that. You're right to that extent that it doesn't really preclude us, but
yes, it doesn't preclude, my lord, the
that
court,
is
my lord,
there.
from hearing.
Absolutely. During the course of the proceeding, before proceeding,
No,
it's
I'm
all
saying, my lord, since this was filed, my lord, before the arbitrator was
go
appointed,
before the
my
arbitrator.
lord, I can, my lord,
Try to plug before the arbitrator, at least before.
my lord, I wanted to, my lord, just give me, my lord, one, my lord, keep going.
Also, my lord, 9-3, your lordship has to.
Then, my lord, I have two requests to make. My lord, one, my lord, is, my lord, we have also, my lord, there's a sir rejoinder, my lord, which we needed to file. My
I'll
lord,
take
to
that,
them, my lord.
but
Kindly, my lord, yes, my lord, kindly, my lord, permit me to file it here. And then, my lord, anyway, my lord, the records will take, my lord, before the, and my lord, kindly, my lord, make it time on before, so, my lord, the arbitrator, at least.
I can't.
Well, at least, my lord, some, my lord, that he'll take it up. This as, my lord, treat this as, my lord, as section 17 application.
This I'll do.
That's, my lord, all, my lord. Kindly, my lord, give me, my lord, leave to.
Sir rejoinder filed by the petitioner is taken on record. Full stop. Learned counsel for the respondent states that the arbitral tribunal has already been constituted. Full stop. Let this application be treated as an application under section 17 of the Arbitration Act before the learned sole arbitrator.
Yes,
Learned sole arbitrator. Full stop. The learned sole arbitrator shall decide the application as expeditiously as possible.
And, my lord, this will be treated, my lord, as the section. So, section. My lord, this is, my lord, the difficulty, my lord. I fail, my lord, every time, my lord, I'm before my. The difficulty, my lord, to put, my lord, my points through.
Yes, Lord. With the above direction, the present petition is answered.
You file the same set. My lord has given us the leave. My lord will file the same set, my lord, before the learned arbitrator.
Yes, the
And,
pleading.
my lord, then we can proceed there. Grateful, my lord.
The rejoinder has not been.
My lord, this is my application. My lord, your lordship on the last occasion passed an order directing that the section officer to file a report regarding the papers, my lord.
Yes.
My lord, this is my lord, the original petitioner, my lord, it arises out of a 3033 under the old act. The petitioner and respondents 4 and 5, they have assigned their rights in respect to a partnership dispute to my clients by way of a deed of assignment. কোথায় লাগানো আছে কোথায় বুঝলাম
Yes, yes, what we saying.
So, my lord, what I was seeking for, deletion of the name of the petitioner and the deletion of the name of the respondents 4 and 5. My lord, the assignment agreement starts at page 13, by which the rights have been assigned.
The volume is not here. The entire record is not here. You have to reconstruct the file.
My lord, then if your lordship passes an order for reconstruction, we will reconstruct the document.
You have to. This court-wide.
My lord, we have a copy of the agreement. That's it, my lord. We have a copy of the
Volume
agreement.
2 is not here.
No, we have copies of the entire petition, my lord, the application. But it needs to be reconstructed. I fully
To be
agree.
reconstructed.
Reconstruct.
This court-wide order dated 4th February 2026 at not a
My lord,
report.
in that case, my lord, I am a applicant, my lord, who has been assigned the rights by the petitioner and respondents 4 and 5. I have not yet been added as a party. Then if your lordship grants the leave to my clients, my lord, that is Sri Hanuman, my lord, the Sri Hanuman, Sri Hanuman Properties Private Limited, who seeks to intervene in this matter. Lord, that assignment agreement starts at page 13, and if your lordship kindly sees at page 17, I am the assignee.
Yes.
Respondents number 1, 2, 3.
She has no objection to that, right?
No.
I'm waiting for the response. Get that, no?
GA1 kar lo. The present application has been filed by Sri Hanuman Properties and Finance.
Properties and Finance Private Limited.
Private
That's
Limited.
a prayer A, my lord, at page 8.
Seeking deletion of the name of the petitioner from the array of parties and substitution of the applicant in their place. Full stop. The applicant has further prayed for deletion of the names of respondent number 4 and 5 from the present proceedings, right?
Yes, madam.
The petitioners in the present proceedings have challenged the arbitral award dated 28/1, right?
Yes, madam.
20 AP number 327. 28/1/2020 passed by the learned arbitrator under section 30 of the Arbitration Act 1940. Full stop. It is the contention of the learned counsel appearing for the applicant that during the pendency of the present petition, present proceedings, the petitioner and the respondent number 4 and 5 entered into the deed of, what is it called?
My lord, award, it's a
deed of conveyance come transfer assignment. This is it, right? Page 13.
Yes, madam.
Dated 15/8/2025 with the applicant, comma, whereby the petition, the respondent number 4 and 5 transferred, sold and assigned their 50% share and interest in all assets, properties and liabilities of Bharat Industries and Commercial Corporation, bracket mein kar dena, since dissolved, along with all claims, entitlement, right and remedies in legal proceedings, comma, as specifically enumerated in Schedule 2, thereto, comma, including the present proceedings in favor of the applicant. Full stop. It was further expressly agreed in the said deed of conveyance cum transfer assignment that the petitioner and respondent number 4 and 5 shall have no subsisting right, title, interest or connection with, comma, nor any right to pursue any legal proceeding whatsoever, including the instant proceedings. Full stop. In view of the aforesaid deed of conveyance cum transfer assignment, comma, the applicant has stepped into the shoes of the petitioner and accordingly seeks substitution of its name in place of the petitioner and deletion of the names of respondent number 4 and 5 from the array of parties in the present proceeding. Learned counsel for the non-applicant submits that they have no objection to the present.
Your Lordship, just without prejudice. I mean, it's
What without prejudice?
just if it is
Have
recorded.
no objection to the present application. Full stop. This court has considered the application and the submission advanced and the materials placed advanced by the parties and the material placed on record. Full stop. It is not in dispute that during the pendency of the proceedings of the present proceedings, comma, the petitioner and the respondent number 4 and 5 executed a deed of conveyance cum transfer assignment dated 15/8/2025 in favor of
12th
the
of August.
15/8.
12th of August 2025. That's at page 13, my lord.
Oh, 15/8. Oh, sorry, 15/8/2025. 15/8. 12th, sorry, 12/8, right?
12th August, my lord.
12/8/2025, not 15. 12/8. हर जगह वो 15 को 12 कर दो. 12/8/2025 in favor of the applicant, whereby they transferred and assigned their duties, right, title, interest, and claims in respect of the subject matter of the present proceedings, including the right to prosecute the same. Full stop. The said deed specifically records that the petitioners and respondent number 4 and 5 shall have no substitute,
shall have no further claims,
shall
after
have
assignment.
shall have no subsisting right, title, or authority to continue or pursue any legal proceedings.
Great.
Full stop. Continue any legal proceeding, comma kar do, comma, including the present proceedings. Full stop. In view of the complete devolution of interest, the applicant has lawfully stepped into the shoes of the petitioners. Full stop. Such substitution is permissible in law, comma, particularly in light of the principle embodied in order 22, right? 2210, order 2210 of the
Order 22 Rule 10, my lord, your lordship had posed a query when I moved
that's what I.
My lord,
Order
this is a
22
Delhi High
Rule
Court
10.
judgment which is reported
Read
in
with section 146 of the Civil Procedure Code 1908. I had also seen it. And
Justice Manmohan Singh, my lord.
and is necessary for effective and complete adjudication of the issues involved. Full stop.
2009
prejudice
SCC
is-
Online Delhi 698 paragraph
I have
23.
it. I have it. No prejudice is caused to any of the remaining parties by allowing such substitution. Full stop. Accordingly, the present application is allowed. The applicant Hanuman Properties and Finance Private Limited is substituted in place of the petitioners, and the names of respondent number 4 and 5 is deleted from the area of title. The cause title shall be amended.
We would also
accordingly
need
within a
orders in
period
terms of res E, F, and G, my lord.
in view of since the application is allowed, the prayer of the applicant in E.
My lord, D, E, F, and G.
D is what?
My lord, the cause title has to be changed, my lord.
E is what?
My lord, the cause title has to be changed. My lord, there has to be amendment carried out.
All right.
Because instead of the
E, F, what is F?
F is, my lord, the re-verification of the petition.
D, E, F,
and the G, my lord, the department is to carry out the amendment.
D, E, F, and G is granted. Is granted.
Grateful, my
With the above observation, the present application stands disposed of.
Grateful.
Regarding this court-wide order dated 4th February 2026 had directed the the Registrar General original side to file a report after conducting an inquiry as to the fact that volume number 2 of the present petition could not be traced out. A report has been filed by the registrar. The report indicates that due to the report admits that the volume has been misplaced. Unconditional apology has been tendered by the registrar. Original side, full stop. Though the report states that they will continue to search for the misplaced volume 2, full stop. The unconditional apology is accepted. The learned counsel for the petitioner shall reconstruct the file and along with the department, and the same shall be placed on record on the next date of hearing. Only volume 2. Only volume 2. Volume 2 of AP is on.
Thanks.
আগে অ্যামেন্ডমেন্ট ক্যারি আউট করতে হবে করে পিটিশনার করে তারপর ক সপ্তাহ লাগবে বলো
गोपाल का मैंने देखा उसमें लिख
5 সপ্তাহ
हाँ देखा मैंने हाँ।
आगे হয়ে গেলে হয়ে
ठीक है क्लोज कर देना
I was beseeching your lordship that if a time frame can be fixed for carrying out this reconstruction.
The same shall be done within a period of 4 weeks. वो जो जहाँ the reconstruction लिखा है ना, the same shall be done within a period of 4 weeks. List after 6 weeks.
And let the main AP appear after 6 weeks. Grateful. Grateful.
Lord, sir, this is my application.
But this is my application, my lord. But this has been made, my lord, pursuant to your lordship's leave granted on 27 January 2026. But basically, my lord, I was supposed to put in a bank guarantee on the basis of which my stay was granted. But it was put in, but my lord, once, my lord, we have failed to extend it within the time frame, my lord. But we have now extended it, and the bank guarantee is extended till November 2026, my lord. So I was only beseeching your lordship for an order that the registrar may be directed to accept this, my lord, bank guarantee, my lord, pursuant to which was supposed to be filed pursuant to your lordship's court's order, my lord.
But I am for the respondent, my lord. My only predicament is, my lord, this is a 2018 matter, my lord. 2018 matter, my lord, the section 34 may be heard out.
I'm ready, my lord, whenever your lordship wants, my lord.
Petitioner, the respondent award holder has become 78 years old.
My lord, whenever your lordship fixes, my lord, I'll be there to assist your lordship.
GA3 of 2026. The present application has been filed by the petitioner seeking condonation of delay in renewing and resubmitting the bank guarantee in terms of the order dated 20th September 2018 and for a direction upon the registrar original side to accept and take on record the renewed bank guarantee. Full stop. Learned counsel for the petitioner submits, learned counsel for the petitioner, Mr. Ray submits that by order dated 20th September 2018, this court directed the petitioner to deposit a sum of rupees 4,874,157 by way of cash and the balance amount of rupees 1,0677,208 by furnishing a bank guarantee issued by a nationalized bank in favor of the registrar original side within 2 weeks from the date of the said order. Full stop. In compliance thereof, the petitioner duly deposited the cash component and furnished the requisite bank guarantee before the registrar, original side. Full stop. It is submitted that the bank guarantee expired on 27, right?
27 November 2020.
27 November 2025, my lord. Sorry.
Full stop. However, owing to inadvertent delay caused by the interdepartmental administrative restructuring within the petitioner's organization, comma, the bank guarantee could not be renewed within time, full stop. The petitioner has now renewed the bank guarantee with validity up to 27/11/2026, full stop. Since there has been a delay in renewal, comma, the registrar original site, comma, declined to accept the same without appropriate orders from this court, full stop. Hence, the petitioner has preferred the present application, full stop. Having considered the reasons assigned in the application and being satisfied that the delay is neither deliberate nor intentional, this court deems it appropriate to condone the delay in renewal and submission of the bank guarantee, full stop. The petitioner is directed to deposit the renewed bank guarantee before the registrar original site within 2 days from date, and the registrar original site is directed to accept the same on record. With the aforesaid direction, the present application stands disposed of.
A direction in the section 34, my lord.
I'm not touching right now.
But
We'll
this
see
matter has not been listed. They are not mentioning. We have tried
We'll
to
see
mention.
that. We'll see that.
Madam,
Judges, could it be recorded that the affidavit of service has been filed? We have filed the affidavit.
Affidavit of service taken on record.
my lord, direction was given in 2024 for listing an urgent hearing. My lord, thereafter the matter has not been mentioned and not taken.
The
up,
matter is listed on the monthly list of March. A small individual, if it could be listed for hearing on a particular date, my lords.
Not right now. We'll see that. Very well. Till GA file.
This is my application, my lord. 32. This is background is, my lord. There is a stay granted by this honorable court on an application filed by the award debtor of an arbitration proceeding for stay of the award, and they have furnished 2 security deposit of 2 crores and 4 crores. Now, I being the respondent number 1, Prime Metal Technologies, we have filed an application for withdrawal of the security deposit. Now, if your lordship sees page number 8, this was the order passed by this honorable court whereby security was directed to be deposited in a interest-bearing fixed deposit amount. But subsequently, by an order dated 24th April, appearing at page 10 of my application, we have filed an application for withdrawal of the said security deposit by furnishing an equivalent bank guarantee. Now, this order was passed directing the learned register to furnish the security deposit to the applicant, which is me, by furnishing a bank guarantee. We have furnished the bank guarantee. Now, there has been letters on the part of the award debtor, the applicant of section 36 application who has obtained stay, that I need to furnish additional bank guarantee on the security, on the interest which has accrued in the meantime. Lordship, I say that this money, the security deposit which has been submitted by them, that is rupees 2 crores. And we have given a bank guarantee of that equivalent sum, praying for that withdrawal. And when we came to know that in the meantime, in the interregnum, an interest has accrued to that amount, I say that interest also I am entitled to enjoy. However, without their consent, the registrar has no authority to disburse that amount, and they are in no way giving the consent to us to encash that security deposit.
My lord, I'm not briefed in this matter. Mr. Choyan Gupta is appearing. I'm just appearing on his behalf. Due to personal medical reasons, Mr. Gupta is out of town till tomorrow. So, my lord, kindly keeps it on Thursday.
Oh, Friday. We'll keep it on Friday. Not today.
Well, the affidavit of service may be taken on record, madam.
Affidavit of service. I'm not passing any order. What is the point? Give it back to him.
Grateful.
Friday. Gabe,
Actually, that is filed by them. That is their application.
So it is their application.
All right.
So I think.
What is your application?
My lord, I'm not briefed in this matter. Mr. Gupta is appearing.
Okay, let it on Friday.
What is the application?
The application actually that they are not giving the without the interest bank guarantee, you have to submit bank guarantee in respect of the interest part is concerned also. What we are submitting.
You have earned the interest. You want the interest, then you have to.
No, that we can submit, your lordship, on the. I will try to satisfy.
You have to take care of the interest part also. Who will take care of the interest part after the? Suppose the matter goes either way, then.
On Friday, we will try to satisfy your lordship, and thereafter we'll.
Somebody has to protect the interest. Who will protect the interest?
They are not even giving the consent in respect
Suppose
of
you
the 2
get the
crores
money.
also. The bank guarantee you have submitting with regard to that, this 2 crore also, they are not giving their consent also. Money we are running from the puller to post from the bank and to the sale office, money to the office of the the petitioner. But they are not giving consent of that also. It's a long time.
So you'll be satisfied with 2 crores, huh? You don't want the interest.
At least 2 crores, so we are entitled as per the order. That is also not
That's what
we are
I'm
getting.
saying.
And thereafter the interest part is concerned, that we are trying to satisfy. We will try to satisfy your lordship. If it is not, then we have to give the bank guarantee.
Item 34, I beg to appear on behalf of the petitioner, my lord. Reason, my lord, application in terms of your lordship, in terms of the liberty given by your lordship to for the purpose of pre-deposit in terms of, my lord, section 19 of the MSME Act. At the time of filing, my lord, I have filed an section 34 application, and thereafter, my lord, I moved an application under section 36(2) of the Arbitration and Conciliation Act, asking for, my lord, here unconditional stay. But in your lordship was pleased to, my lord, dismiss that application that is appearing at, my lord, page 9, with a, my lord, liberty to, my lord, give the, my lord, pre-deposit. So, my lord, I have, my lord, made this application for the purpose of, my lord, pre-deposit to the for an amount to the 75%. And lord, I have, my lord, made a demand draft ready in favor of, my lord, the registered ordinance, Calcutta High Court, for an amount of rupees 36,77,052 rupees. Awarded amount, my lord, along with interest 49 lakhs 2,736.
Yes.
My lord, I appear for the respondent. My lord, I am not standing in the way. Only thing, my lord, after their deposit, my lord, I may be permitted to make an application and withdraw that amount. That is my prayer.
That's a different thing.
And, my lord, so far as section 34 application is concerned, my lord, there was the application was filed, my lord, beyond after 90 days, but within a period of, my lord, 120 days, there was with 28 days. 28
tomorrow. We'll decide this. We have
tomorrow.
Full court tomorrow. Yeah, he based an application.
Next matter will be adjourned, your lordship.
Small prayer, non-commercial matter, lordship will not.
3:30. Yes, full court. Lordship.
Tomorrow.